HighBridge, a division of Recorded Books, presents Who Says You're Dead? Medical and Ethical Dilemmas for the Curious and Concerned, by Dr. Jacob M. Appel, M.D. Read by Jonathan Yen. Disclaimer. The names of the doctors in the hypothetical dilemma portions of this book are drawn from literature, film, television, and even comics. They are all fictional. Any resemblance to real medical professionals, living or dead, is entirely coincidental. No connection is intended between the fictional doctors and the material described in the dilemma. Introduction. Today's hospitals and clinics are the settings of some of the most challenging and controversial ethical dilemmas our society confronts. Every day, it seems, a pioneering researcher or clinician announces a new breakthrough: hand transplants, cloned sheep, targeted biological cancer therapies, cognitive enhancers, pre-implantation genetic screening, transgenic mice. The list of scientific miracles seems endless. With these technologies, of course, arise far more complex moral challenges. How to allocate scarce donor hearts and kidneys among potential recipients, for example, is not an issue unless the immunosuppressive drugs that prevent our bodies from rejecting those organs exist. Now they do. Two recent technological developments offer windows into the strikingly different sorts of ethical challenges that such advances pose. One of these innovations is three-parent conception. As listeners may or may not recall from high school biology, most of our DNA is housed in the nuclei of our cells, but some of our genetic blueprint is contained in small organelles outside the nucleus called mitochondria. Both types of DNA are necessary to produce a healthy baby. Under rare circumstances, the DNA in the mitochondria becomes defective through mutations. As a result, babies are born with debilitating genetic diseases. These conditions often run in families. To prevent these diseases, doctors can now take the nucleus of an egg cell from a potential mother who comes from such a family and combine it with the mitochondrial DNA of a second, unrelated woman. This process is known as cytoplasmic transfer. If this combined egg is then fertilized by a sperm, the result will be a baby with DNA from three distinct biological parents, what the media has dubbed a three-parent baby. On the one hand, this is a great breakthrough. Women once faced with the choice of conceiving a sick child or no child at all can now give birth to healthy offspring who live long, meaningful lives. On the other hand, such a process raises novel questions. Should two mothers be listed on this child's birth certificate? What happens if the woman who contributed mitochondria demands partial custody, visitation rights, and inheritance? Alternatively, does the child ever have a right to learn the identity of the mitochondrial donor, or the donor's medical history? And in the age of surrogate motherhood, if the embryo is implanted inside a third woman's uterus, what are the ethical and legal implications for a four-parent baby? While more than a dozen babies have been born over the past 2 decades through cytoplasmic transfer, many of these questions remain unresolved. At the opposite end of the technological spectrum stands an advance far more familiar to the average healthcare consumer: the rise of the electronic medical record, EMR. These days, anyone who visits a doctor's office or hospital emergency room has likely encountered the ubiquitous appearance of the computerized chart. Experts tell us that these EMRs will decrease medical errors and speed the transfer of health information. The ultimate goal, for many, is a so-called intraoperative system, where a patient can walk into any hospital or physician's office in the nation and the staff will immediately be able to access the patient's medical history, current medications, and regular healthcare providers' contact information. This technology might prove particularly valuable in emergencies or when a patient has lost consciousness. At the same time, it is fraught with the potential for lost privacy. Millions of healthcare professionals would require access to such a system for it to function well, but some patients may not want their records available in this manner. They may object to their podiatrist knowing that they suffer from a mental illness, or their dentist learning what method of contraception they use. The potential for abuse also remains glaring. How will the system know if a pharmacist from Wyoming accesses the medical records of his soon-to-be son-in-law in Florida in order to discover whether his daughter will be marrying a man with a history of drug addiction? And if he does breach the system in this way, how should we punish him? Firing the victim's future father-in-law may actually exacerbate the injured man's misfortune, and will certainly not put the genie back in the bottle. And then, of course, there is the possibility that hackers will break into the system and post the medical records of everyone on the Internet. Certainly, these pitfalls require a careful balancing between privacy rights and access to top-notch care. As a practicing psychiatrist and bioethicist, I explore these exciting and often daunting ethical dilemmas every day. Over the course of nearly 2 decades teaching at Brown University, Columbia University, New York University, and the Icahn School of Medicine at Mount Sinai, I have written a trove of these difficult conundrums to stimulate discussion among medical students and residents. Some are drawn from the headlines, others loosely modeled on cases reported in professional journals. A few, painstakingly disguised, come from my own clinical encounters. Whether you are planning a career in healthcare, or you are a layperson intrigued by the ethical issues you often witness all too briefly on popular television shows, the dilemmas that follow are designed to let you investigate your own values, engage with difficult, real-world issues, and argue, in good cheer, with friends and family across the dinner table. The commentary provided after each conundrum is not intended to sway your opinions. Rather, these are reflections that offer some of the real ways in which established bioethicists, clinicians, and policymakers have tackled similar moral quandaries. Some of these quandaries may arise in your own life, and there is value in having thought about the issues in advance. The hope is that you will examine these questions from multiple vantage points, whatever your ultimate feelings, and will recognize that intelligent people of good will may arrive at different conclusions. In the hospital or in the legislature, addressing these highly fraught subjects can prove emotionally grueling. Fortunately, discussing them hypothetically in your own living room should be precisely the opposite, invigorating and inspiring. Above all, the goal of this volume is to convey the intellectual pleasure of engaging with complex ethical questions, to let you do what professional bioethicists do every day. So I do hope you enjoy. Jacob M. Appel, M.D., J.D., M.Phil, M.Ph., M.F.A., Director of Ethics Education in Psychiatry, Assistant Professor of Psychiatry and Medical Education, Icahn School of Medicine at Mount Sinai. Part 1. Inside the Mind of a Doctor. The ethical norms of the physician-patient relationship have evolved considerably since the Hippocratic Oath of ancient Greece forbade doctors from performing surgery. As late as the 19th century, many medical practitioners questioned the value of empirical evidence and offered remedies grounded in unproven theories, including bloodletting, purgatives, and toxic metals like mercury and arsenic. The effective arsenal of the medical practitioner was limited: citrus for scurvy, iodine for goiters, inoculation for smallpox. Encounters with physicians often did more harm than good. Although some states attempted to rein in the profession, beginning with the passage of New York's Medical Practices Act in 1806, credentialing standards proved extremely lax. By 1860, the United States had one physician for every 571 people, by far the highest rate in the world. Over the next century, the American Medical Association, AMA, and various other professional societies played an instrumental role in reshaping healthcare into one of the nation's most heavily regulated fields. Doctors are now licensed, and their numbers are strictly limited. Many medications require a prescription. An age of scientific discovery and rapid advances in technology, including the ongoing genetic revolution, have helped to realize cures that seemed unfathomable only a generation ago. How doctors should use this newfound power remains one of the central ethical challenges of the 21st century. 1. You're not my real dad. Fred is a 75-year-old widower who suffers from kidney failure and faces a lifetime on dialysis. After a lengthy discussion with his longtime physician, Dr. Arrowsmith, Fred decides to seek a potential kidney donor among his friends and family members. His only daughter, Linda, who is nearly 50, agrees to be tested to see whether she is an appropriate match. The results of the ensuing tests shock Dr. Arrowsmith. Not only is Linda not a match, but genetic markers reveal that Linda cannot be Fred's biological daughter. In other words, Fred's late wife likely had an extramarital relationship that led to Linda's conception. Should Dr. Arrowsmith tell either father or daughter of this discovery? Reflection. False paternity. Misattributed paternity, commonly known as false paternity, is not an uncommon phenomenon. Estimates suggest that 1.7 to 3.3% of children are mistaken regarding the identities of their biological father. This occurrence has significant implications well beyond healthcare. For example, a staple of junior high school science classes once was having students perform ABO Landsteiner blood typing on themselves and then comparing their blood types to those reported by their parents. One can imagine the family discord such an exercise might create if parents and children display biologically incompatible results. On the one hand, if Dr. Arrowsmith decides to reveal Linda's false paternity, the consequences may prove psychologically devastating for both father and daughter. On the other hand, concealing the information has significant healthcare implications as well. For example, Linda may believe both of her parents to be Scandinavian. If she has children of her own, she may forego genetic testing for diseases not frequently found among Scandinavians, such as Tay-Sachs disease, a deadly childhood illness that is most common among Eastern European Jews, French Canadians, and Louisiana Cajuns. But if Linda's biological father were not Scandinavian, her own offspring might still be at risk. Not knowing her authentic family history could lead to preventable diseases in her own children. Linda might also unwittingly report an incorrect family history to her doctors, who could then underestimate her risk of everything from early-onset colon cancer to suicide. One can also imagine a different case where the daughter is found not to be a biological child, but is still a potential match as a kidney donor. Under those circumstances, sharing the false paternity results might deter the daughter from donating a kidney and thus prove medically compromising to the potential recipient. Ethicist Baron Lerner once described a case similar to this one in a New York Times column. In that case, which occurred at the University of Toronto, the doctors chose to disclose the discovery, which the family, after initial shock and distress, was able to accept. The patient's daughter reported being grateful to learn of the misattributed paternity from the medical staff, rather than later under different circumstances. Other families might respond with less equanimity. How hospitals should handle these cases of unexpected non-paternity remains controversial. Some hospitals now have patients and family members sign disclaimers prior to organ transplant compatibility testing, which specifically state that discoveries of false paternity resulting from the testing will not be disclosed, while others continue to believe that they have an ethical obligation to share such discoveries. 2. How many of your patients survive? Dr. Doolittle is the chief of neurosurgery at a well-respected community hospital. A retired couple, Bonnie and Stan, arrive at the emergency room. Stan is complaining of the worst headache of his life, and a brain scan reveals he is suffering from an aneurysm that requires surgery within 12 to 24 hours, or he will likely die. Bonnie asks Dr. Doolittle what the success rate is for the surgery, and he tells her, truthfully, that 60% of his patients survive the procedure. Dr. Doolittle knows that at a hospital 20 minutes away by ambulance, another doctor, Dr. Quincy, has a surgical survival rate of 85%. Should Dr. Doolittle volunteer this information to Stan and Bonnie? Reflection. Informed consent. Informed consent is one of the foundations of modern Western medicine. In order for patients to make meaningful decisions about their health care, they have to know the potential risks and benefits of each of these decisions. In fact, being able to state the risks and benefits of a given medical intervention is one of the requirements for determining whether a patient is mentally sound enough to make his own choices. At the same time, physicians are not expected to outline all of the risks of a particular intervention. For example, during an appendectomy, it is theoretically possible that a patient might fall off the operating table, hit her head, and suffer brain damage. But the chances are rather remote, so this is not a part of the standard informed consent for the procedure. The truth is that, with regard to cognitively intact patients, informed consent is actually a misnomer. It does not matter whether the patient actually understood enough to consent meaningfully. What matters is that the physician provided sufficient information for a reasonable or ordinary person to have understood the risks and benefits. Some plastic surgeons even record their informed consent process on video, so that in cases of alleged malpractice, they can prove to a jury precisely what they said. Why such an objective, reasonable person yardstick? Because a subjective approach, that is, one that asks whether this particular patient actually understood the risks, would open the door to second-guessing and even outright perjury by the patient at a future malpractice trial. Hindsight is 20/20. Football fans understand how easy it is to play Monday morning quarterback. Unfortunately, even with rigorous standards, informed consent often fails to serve patients' needs. Medical historian David Rothman reported in 2006 that anywhere from 25 to 50% of patients and subjects do not understand what they have agreed to. Physicians are generally not expected to share the success rates of other providers, although there might be an exception at the extremes. A physician who has never performed the operation before, for instance, might be expected to reveal this information to a patient. However, society generally places the burden on the patient to shop around or to get a second opinion. If Bonnie had asked Dr. Doolittle directly whether other physicians could perform the aneurysm repair better, he would be wrong to lie point blank, but he could probably get away with simply telling her that he cannot speak for the success rates of other providers. One should note that an alternative rule, which would compel physicians to share their comparative success rates, might have the unintended consequence of steering traffic toward a handful of first-rate providers. Over time, fewer surgeons would master the technique for aneurysm repair, and overall access to quality care might be reduced. Success rates can also reflect the patient population served, so compelling surgeons to share their outcome data might lead them to cherry-pick their patients, making it more difficult for the sickest patients to find providers. Finally, in many cases, sharing such information would help only wealthy patients. If a patient lives in poverty in a housing project in New York City, being told that the success rate for treating a particular condition is better at the Mayo Clinic in Minnesota may not prove very helpful. If the patient cannot get to the Mayo Clinic, this knowledge will not help him medically and could harm him psychologically. 3. Please don't tell anyone about my crime. During a routine session with his longtime psychiatrist, Dr. Sarah Cooper, 35-year-old Marcel confesses to a crime from his college years. While arguing with a neighbor, Olivia, over loud music, he lost his temper and shoved her. Olivia fell down Marcel's kitchen staircase and broke her neck, dying instantly. Marcel panicked and buried the body in a state park many hours away. When pressed by Dr. Cooper, he reveals the precise location. The body has never been found, and Olivia remains listed as a missing person. Dr. Cooper believes Marcel, who is now happily married and has 2 young children, when he swears the death was accidental. Marcel is unwilling, however, under any circumstances, to convey this information to the authorities. He forbids Dr. Cooper from doing so as well. Dr. Cooper looks up the case on the internet and discovers that Olivia's parents continue to hold out hope that she remains alive. Each year, they record a video plea for her safe return that is broadcast on the local television station. Dr. Cooper realizes that merely informing the family or the authorities anonymously that Olivia is dead will not resolve their uncertainty and will perhaps raise even more questions. Yet she fears that notifying them of the location of the body might lead them to forensic evidence that will incriminate Marcel. Should Dr. Cooper reveal the location of Olivia's body to the woman's family and/or the police? Reflection. Doctor-patient confidentiality. Confidentiality is essential to the relationship between physicians and patients. Reliance on confidentiality proves especially significant in patient interactions with mental health professionals, such as psychiatrists and psychologists. If a patient is unwilling to speak candidly with his psychiatrist for fear of disclosure, the result may be misdiagnosis or inappropriate treatment. These general principles are enshrined in the Health Insurance Portability and Accountability Act of 1996, better known as HIPAA, but they date back to the Hippocratic Oath and many other professional creeds. Although federal law and professional guidelines generally leave some limited opening for breaching confidentiality in pursuit of the general welfare, even these exceptions have narrowed in recent years. In the landmark case of Jaffe v. Redmond, the U.S. Supreme Court established a psychotherapist patient privilege, which generally affords patients the right to prevent their psychiatrists and psychologists from testifying against them in court. In fact, the protections from psychiatrist-patient confidentiality are generally much stronger and broader than those that apply to other physicians. Many states follow what is known as the Tarasoff rule, which not only allows but requires psychiatrists and often other mental health professionals to breach confidentiality to warn and protect potential victims of future crimes. At least one state, Iowa, in a high-profile arson case, extended this duty to include the protection of private property. A 1994 study by Marcus J. Goldman and Thomas C. Gutheil revealed that many psychiatrists believe a similar legal duty exists to report past crimes, but this is not the case. In fact, doing so under some circumstances opens the psychiatrist up to malpractice liability. The Principles of Medical Ethics of the American Psychiatric Association, APA, limit the permissibility of such breaches to situations in which the psychiatrist is protecting the community from imminent danger. These circumstances might include, arguably, a case where an innocent third party has been convicted of the patient's prior crime. At least one leading psychiatric ethicist, Paul Applebaum, has raised the possibility that the exception might also apply when the victim is suffering substantially as a result of the patient's failure to confess. It is not much of a stretch to apply a similar exception in the case of Marcel and Olivia, when the victim's family appears to be suffering. However, such breaches run the risk of causing larger damage. Mental health patients may then hold back information about past criminal acts whose disclosure is vital to their treatment. Such well-founded mistrust would damage the patient's own well-being without any clear benefit to their victims or their victims' families, as psychiatrists would never hear many patient confessions at all. 4. Please don't put it in my chart. Carrie is a 25-year-old woman who lives with a violent male partner, Charles. She arrives at the emergency room of her local community hospital with a black eye and a broken wrist. After some coaxing, she tells the physician on duty, Dr. Zira, that her partner is responsible for her injuries. Dr. Zira documents this in the medical record. Several hours later, once her wrist has been cast and she is ready for discharge, Carrie summons Dr. Zira back to her bedside. "Please don't put anything in my chart about Charles hurting me," she says. "He has friends who work at this hospital. If they find out what I told you, it will get back to him and he'll hurt me again." There is an override in the hospital's electronic medical record, EMR, system to remove information that is both inaccurate and could be dangerous, such as a wrong blood type, from a patient's chart. Should Dr. Zira use this method to remove this accurate information from Carrie's chart? Reflection. Privacy and medical records. Prior to the 1970s, many healthcare professionals looked askance at anyone requesting access to their own medical records, fearing that patients would generally fail to understand the contents. Concerns over litigation, the loss of medical mystique, and convenience likely played a role in such secrecy as well. Since 1996, HIPAA has guaranteed patients the right to view their medical charts within 30 days. Many state laws require even more immediate access. The federal statute also gives patients the opportunity to append a statement of disagreement to their medical record if they object to any of its contents. Such statements may prove of value when there is a genuine dispute over facts. Yet, in cases where the patient's concerns are for privacy rather than accuracy, such a statement is of little value. As a general rule, hospitals limit employee access to medical records to individuals directly involved in a patient's care. However, policing access can prove challenging, especially in the era of EMRs, and enforcement often occurs only after the fact. Firing a worker who allegedly accessed and shared private information may prove little comfort to a patient whose secrets have already been divulged. In Carrie's scenario, she appears to have sincere concerns for her personal safety. She is frightened that her partner's friends may access her records without authority and reveal the contents to him. She may also fear that the secrets she related to Dr. Zira could be used against Charles in court, which is likely permissible in certain states and under federal evidence rules. Many hospitals allow celebrity patients and others with compelling needs to register under aliases. Some rogue hospital employees have learned this fact the hard way when they have illegally accessed the charts of famous patients, like Bill Clinton or Farrah Fawcett, only to discover that they have accessed fake records instead. It is not clear whether Dr. Zero's hospital offers such an option to patients like Carrie, or if it did, whether doing so would genuinely protect her from the staff members.
Sample complete. Ready to continue?